The Senate has had multiple votes going on throughout the day, but the main one, I want to put this up on your screen, is what we now know, that the Senate did vote on the Shutdown Fairness Act. That vote ultimately failing at the beginning of this hour. And so if you're not familiar with what we're talking about here, today the Senate was voting on whether or not to advance the Shutdown Fairness Act. This was a bill that was put forth by GOP Senator Ron Johnson. The current version of the legislation would pay federal employees who have continued to work throughout this shutdown, but Johnson has an amendment that would also pay furloughed workers.
Let me annotate what you just heard, because there are several distinct data points embedded in that segment, and they deserve to be unpacked individually. First data point, the Senate's Shutdown Fairness Act vote failing. I'm noting this not because it's the central subject of today's analysis, but because it is relevant context. Senator Ron Johnson's bill, which would have addressed pay for federal employees affected by the shutdown, failed to advance. That failure is part of a broader pattern of legislative gridlock that is directly related to the political environment surrounding this presidency. A presidency under acute legal pressure tends to generate legislative paralysis because political capital that would ordinarily be deployed on policy is being consumed by defensive legal and political operations. That is a governance cost. It is documentable and it is real. Second data point, judges are not letting Trump get away with trying to stall. I want to be analytically precise about what this phrase actually means in legal terms, because the conversational framing undersells the significance. When a judge rejects a motion to dismiss or a request for delay, the judge is not simply saying no. The judge is issuing a formal documented ruling, entered into the permanent legal record, that the legal arguments presented by the defendant's counsel do not meet the threshold required to justify the requested relief. When those rejections accumulate across multiple motions, across multiple case types, in multiple jurisdictions, what the accumulated record documents is the systematic failure of a legal strategy. A legal strategy that fails systematically in documentation is not a strategy that will eventually work. It is a strategy that is producing a paper trail of documented defeats. And that paper trail matters, not just for the cases in question, but for every subsequent proceeding, every future judge, and every appellate review that will examine the full record. Third data point, the 10th contempt finding in the hush money case. I want to hold that number for a moment. 10, not once, not twice, not a single procedural disagreement that was eventually resolved. 10 documented instances of conduct that a sitting judge formally concluded constituted contempt of court. Each one entered into the record, each one accompanied by a documented judicial finding, each one escalating the documented pattern of defiance. The significance of reaching 10 contempt findings in a single case is not primarily about the fines attached to each finding. The significance is what the 10th finding tells you about the behavioral relationship between this defendant and the judicial authority of the court. Judges do not arrive at 10 contempt findings by accident. They arrive there because the defendant demonstrated 10 separate times that the previous finding was insufficient to produce compliance. That is not a legal technicality. That is a documented behavioral record.
The federal judge in Donald Trump's New York criminal case found the former president in contempt for a 10th time today. The decision is a response to the former president repeatedly violating his gag order. Judge Marchand is now threatening Trump with jail time if he continues this behavior. The former president is charged with 34 felony counts for allegedly falsifying business records to cover up an alleged affair ahead of the 2016 election.
The Bondi firing, April 2nd, 2026. I want to use this event as an analytical lens because it reveals something important about the structural position this administration is in, something that the straightforward Trump fires another loyalist framing tends to obscure. Here is the structural point. The firing of Pam Bondi is documented evidence of the limits of executive control over legal outcomes. Bondi was not fired for disloyalty in the conventional sense. By all documented accounts, she was intensely loyal to Trump personally. She was was fired because loyalty, in this context, was functionally insufficient. The president needed results. Specifically, he needed the Department of Justice to serve as a mechanism for legal protection. And the documented fact is that the DOJ, even under a loyalist attorney general, cannot accomplish that goal. Why not? Because the legal cases that represent the most acute threat to Trump are not federal cases that the DOJ controls. They are state cases, specifically New York, over which the federal DOJ has no jurisdiction. A federal attorney general cannot direct a Manhattan district attorney. A federal attorney general cannot remove a New York state judge. A federal attorney general cannot overturn a Manhattan jury verdict. The constitutional architecture of American federalism places those proceedings entirely outside the reach of federal executive power. This is not a political observation. It is a structural one. And the Bondi firing documents that the administration has now confirmed through action that it understands this structural reality and is frustrated by it. The response to that frustration is also documented. Public attacks on sitting federal judges, including a documented call by the president beginning March 15, 2026, for the impeachment of Judge Boasberg and other judges who had ruled against his executive orders. Let me be analytically precise about what those calls for judicial impeachment represent. Federal judges serve with lifetime appointments under Article 3 of the Constitution. They cannot be fired by the president. They cannot be reassigned. They cannot be disciplined through the executive branch. The only mechanism for removing a federal judge is impeachment by the House and conviction by the Senate, a process controlled by Congress, not the executive. When a president publicly calls for the impeachment of sitting judges who have ruled against his policy agenda, the president is not exercising a constitutional power. He is attempting to use political pressure to influence the conduct of the judiciary, which is a separate and independent branch of government. That is a documented institutional norm violation of considerable gravity. But here is the analytical point that the outrage cycle tends to miss. It is also evidence of institutional weakness, not strength. A president who is successfully wielding institutional power does not need to call for the impeachment of judges. He achieves his objectives through the normal exercise of executive authority. The calls for judicial impeachment are documented evidence that the normal channels are not producing the desired outcomes, that the legal architecture is, from the administration's perspective, failing to provide the protection that was anticipated. That failure is precisely what the documented record predicts. Independent federal judges with lifetime appointments, applying documented legal standards, are not subject to the political calculations that affect other institutional actors. That insulation is a feature of the constitutional design, not a bug. And the documented evidence suggests it is functioning as designed. Want to spend time on the contempt issue because it is where the analysis gets constitutionally complex and where most coverage substitutes drama for precision? There are two legally distinct categories of contempt of court, and they have different implications for a sitting president. Civil contempt is coercive in nature. Its purpose is not to punish past defiance, but to compel future compliance. A civil contempt order typically says, you will do X, and until you do X, you will face consequence Y. The consequence is prospective. It lifts when compliance occurs. In civil contempt proceedings, the contemner essentially holds the key to their own jail cell. They can purge the contempt finding by simply complying. Criminal contempt is punitive in nature. Its purpose is to punish past defiance as a completed offense. It does not lift when compliance occurs because the offense has already been committed. Criminal contempt findings can result in fixed sentences, imprisonment, fines that must be served or paid regardless of subsequent conduct. The documented contempt findings against Trump in the hush money case were primarily civil contempt findings. They attached fines to documented violations of the gag order. The fines escalated with each violation. The documented pattern, reaching 10 separate findings, reflects a situation where the fines were not achieving their designed function of compelling compliance. When fines reach that ceiling of deterrent effectiveness, the next logical tool in the contempt framework is incarceration. Judge Merchan documented this in his formal warnings. Continued violation of the gag order could result in jail time. Now, here is where the constitutional analysis becomes genuinely complex, and I want to address it with the precision it deserves. Can a sitting president be jailed for contempt of court? The honest analytical answer is, this is a genuinely unresolved constitutional question. It has never been directly adjudicated. There are competing legal frameworks. The argument against incarceration is functional. Imprisoning a sitting president would prevent them from exercising their constitutional duties, receiving foreign dignitaries, commanding the military, executing federal law, appointing officers. The argument tracks the same logic that led Judge Merchan to issue the unconditional discharge, that the presidency creates a unique constitutional situation that limits the available tools for judicial enforcement. The argument for incarceration is principled. The rule of law, by definition, cannot have categorical exceptions based on the identity of the contemner. If the rule of law does not apply to the president, then the president is not subject to the law, which is the precise claim that the D.C. Circuit unanimously rejected in its immunity ruling. The documented record shows that as of this recording, no judge has actually moved to incarcerate Trump despite documented contempt findings and formal written warnings. The warnings have been issued, the documentation is in the record, the threshold has not been crossed. What that tells us analytically, the judiciary is navigating the outer boundary of constitutional authority in real time, in a situation that the framers did not fully anticipate, and that existing precedent does not cleanly resolve. The judges are moving carefully, they are creating a documented record, they are escalating incrementally, they are not acting impulsively. That is actually the judiciary functioning as designed, as a deliberate, process-bound institution that moves with documented justification rather than reactive urgency. The three scenarios, a structural analysis of the midterm calculus. Let me lay out three scenarios for the period between now and the 2026 midterms, not as predictions, but as documented structural possibilities, each with its own set of institutional dynamics. Scenario 1. Trials proceed before the midterms. If one or more federal or state criminal trials against Trump are scheduled and actually commence before November 2026, the political and governance consequences are significant and documentable in advance. A sitting president participating in a criminal trial, providing testimony, being present for damaging testimony from witnesses, having evidence presented publicly in a formal legal proceeding, is an event with no direct precedent in American history. The daily news output from an active trial would dominate the political environment. The public would have access, through documented trial proceedings, to evidence and testimony about the specific conduct at issue. This matters for the midterm calculus in a specific, documentable way. It is not the verdict that drives electoral outcomes in this timeline. Trials take time. Convictions, if they come, would almost certainly come after the midterms given realistic scheduling. What drives electoral outcomes is the documentary experience of the trial itself. The public's sustained exposure, over weeks or months, to the evidentiary record. The documented research on electoral behavior consistently shows that voter attitudes toward candidates are more strongly influenced by direct exposure to evidence than by media framing of that evidence. A trial creates direct exposure. It is a fundamentally different informational environment than news coverage of a trial. Scenario 2. Delays succeed and trials are pushed past the midterms. If Trump's legal team successfully obtains delays through scheduling arguments, constitutional motions, or appellate stays that push all major trials into 2027, the political calculus shifts. In this scenario, Trump enters the midterm cycle as a defendant in multiple criminal cases, but not as an active trial participant. The Republican argument that the prosecutions are politically motivated is easier to sustain in the absence of actual trial testimony because there is less direct evidentiary exposure for voters. However, this scenario does not eliminate the legal risk, it defers it. A former president who has successfully navigated the midterms without a conviction still faces trial in early 2027, and the documented pattern of judicial resistance to delay requests means this scenario requires judges to reverse the behavioral pattern they have been documenting. That reversal is not impossible, but it is inconsistent with the documented trajectory. Scenario 3, self-pardon and executive intervention. This scenario involves Trump directing his attorney general, whoever currently holds that position after the Bondi firing, to drop federal charges or attempting to execute a self-pardon for federal offenses. The self-pardon question is another genuinely unresolved constitutional issue. The pardon power under Article 2 is extraordinarily broad. There is an argument that it has no exception for self-application. There is also the documented constitutional principle that no person should be a judge in their own case, a principle with deep roots in Anglo-American jurisprudence. More practically, even if a self-pardon were constitutionally valid for federal offenses, it would have no effect whatsoever on state prosecutions. New York's cases are entirely beyond the reach of federal pardon authority. The documented structural constraint on executive power, that it cannot reach state judicial proceedings, applies with equal force to the pardon power as it does to DOJ direction. The documented political consequence of an attempted self-pardon would be severe. The documented evidence from the Bondi firing, and from every prior instance in which Trump has publicly exerted control over legal proceedings, is that such actions generate institutional resistance, congressional backlash, and public disapproval that ultimately compounds rather than resolves the underlying legal exposure. The judicial independence variable: why the attacks on judges are structurally counterproductive. I want to close this analytical section with an observation that I think is underappreciated in the current coverage environment. Trump's documented attacks on sitting judges, including the March 15, 2026 calls for Judge Boasberg's impeachment, are not just norm violations. They are strategically counterproductive in a specific, documentable way. Federal judges are human beings with institutional identities, professional reputations, and career incentives. But the specific structure of the federal judiciary, lifetime appointments, salary protections, the formal insulation from political pressure that Article 3 provides, means that those attacks cannot produce the outcome Trump appears to want, which is judicial deference or withdrawal. What the attacks can and do produce is a more carefully documented record. When a defendant publicly attacks a judge's legitimacy, that judge has institutional and professional incentives to ensure that every subsequent ruling in that case is meticulously reasoned, precisely documented, and airtight on the law. Because the documented attacks create a documented record of pressure, and the judge's rulings need to withstand appellate scrutiny in that context. In other words, the documented attacks on the judiciary are, from a pure legal strategy standpoint, making the legal situation worse. They are not producing the desired judicial behavior. They are producing a more carefully fortified judicial record, one that is harder, not easier, to overturn on appeal. This is the behavioral pattern I described at the opening of today's analysis, and it is the pattern that, when you trace it through the full documented record, explains why the legal situation is deteriorating rather than stabilizing despite, or more precisely, because of, the escalating confrontational posture toward the courts. Let me return to where I started, the pattern. A president attempts to delay a legal proceeding. A judge rejects the delay. The president attacks the judge documents the escalation. The proceeding advances anyway. I have now walked you through 4 documented iterations of that pattern: the hush money case, the immunity ruling, the contempt escalation, and the Bondi firing. And what the documented record shows is that each iteration of the pattern has resulted in the same outcome. The legal architecture has held, the judicial findings have accumulated, and the president's legal position has deteriorated. This is not an accident. It is the constitutional design functioning as intended. The founders built the federal judiciary with structural insulation from political pressure, specifically because they anticipated that executives would, at some point, attempt to use political power to override legal accountability. Lifetime appointments, salary protections, the formal independence of Article 3. These were not administrative conveniences. They were deliberate architectural choices designed to ensure that the rule of law could withstand pressure from the most powerful office in the country. The documented record of this administration's interaction with the federal judiciary is, in a real sense, a stress test of that design, and the documented results, as of this recording, show the design is passing the test. Here is what the current documented record establishes. 1. A sitting president holds 34 documented felony convictions under state law, the first in American history to hold that status. 2. The D.C. Circuit unanimously documented in a formally entered ruling that no president possesses immunity from criminal prosecution, a finding that removed the primary legal defense in multiple federal cases. 3. 10 documented contempt findings in a single case, with formal written judicial warnings about potential incarceration that remain active in the record. 4. The firing of the Attorney General on April 2, 2026, documented as a consequence of her failure to deliver legal protection, a structural admission that executive control cannot reach the judicial proceedings that pose the most acute risk. 5. Documented public calls for judicial impeachment, not as an exercise of constitutional power, but as an attempt to use political pressure against the one branch of government that is structurally insulated from it. 6. A consistent documented pattern of judicial rejection of delay requests across jurisdictions, across case types, across presidential appointments, pointing toward trial dates that increasingly risk overlapping with the 2026 midterm campaign. The analytical conclusion is not dramatic, it is clinical. This is a documented governance and accountability crisis with a trajectory. The trajectory is documentable. The historical precedents are available. The institutional dynamics are predictable. And the documented record, read without spin in either direction, does not describe a situation that is stabilizing. What it describes is a situation in the middle of its arc. This is Matthew John Turner. I document the record, I run the analysis, I don't tell you what to think, I show you what the evidence says and let you draw your own conclusions. But I will tell you this much. The question I want you to sit with after today's analysis is not, is Trump guilty? The jury already answered that question. The documented answer is in the legal record.